Let us understand the Negotiable Instrument Amendment Act 2015, which is effect of making two changes in the Negotiable Instrument Act, right? One is under section 6, which is the definition of a check, and another is the section 142, cognizance of an offence. This change in the Negotiable Instrument Act, that is the Negotiable Instrument Amendment Act 2015, is applicable to the IPCC student of a CA, CWA student of intermediate, right, and other relevant courses. Let us understand the two changes one by one. The first, section 6. Now section 6, probably you are aware that it is a definition of the word check. And I hope that every one of you are aware about the definition of a check, but it contains the two explanations. The section 6 is having a part 2, part A and part B, two parts, right? The part A contains the explanation or understanding with regard to the electronic check, while the part B contains the explanation with regard to the truncated check. Now this Amendment Act 2015 has brought the changes under the part A, right? Earlier the check include the electronic check. Now also definition of a check include the electronic check. But the definition or explanation of the word electronic check has been changed. Earlier it used to say the exact mirror image of the physical check, which has been signed with the digital signature or a biometric signature with the minimum security. Now that was an earlier explanation. Now this explanation read as the check include the electronic check, and it means electronic check means a check drawn in an electronic form. Now what the change has been carried out, earlier it was having the mirror image of the physical check. So the word has been replaced, right, by using any computer resources and signing with the help of the secure system with the digital signature, with or without the biometric signature, and asymmetric crypto system, or with the electronic signature as the case may be. Earlier it used to provide it should have been signed with the minimum security standard or minimum security. Now here it provides the standard of the security for the purpose of signature, right? It says that it should have been signed with the secure system, not with the minimum security or minimum standard of a signature. So from the perspective of the academic, there could not be a major change, but from the technical point of view, or from practice point of view, there will be a great change, right? And this change or shift indicate that the most concern legislature concerned about the security. Now another change, another amendment, section 142. Section 142 clause 2, cognizance of offence, is another area, another section where the amendment has been effected by the Negotiable Instrument Amendment Act 2015. Section 142 is related with the cognizance of an offence. I hope you understand the meaning of the word cognizance. It means the authority, court, cannot take the investigation or cannot take the matter without a complaint being made by someone in writing. Section 142 clause 2, where the amendment has been carried out, right, and it now read as the offence is under section 138. Remember, section 138 of the negotiable instrument is a very important section. Section 138 of the negotiable instrument deal with the dishonor or abusement of a check. and that's why it is a very important. Remember, the section is only applicable to the check and not to any other instrument or any other instrument dishonour. The offence under section 138 shall be inquired into and tried only by the court. Now it is the change with regard to the jurisdiction of the court, right? It is a change with regard to the jurisdiction of a court, right? Within whose local jurisdiction, if the check is delivered for a collection through an account, the branch of the bank where the payee or a holder in a due course. Now the words are very complicated or heavy. As the case may be, comma, maintain the account is situated. In a very simple language, say for example, A has granted the check to the B and the check has been dishonoured. Question here is that where the complaint should be filed by the B, whether complaint should be filed within the area where the check has been dishonoured or within the area from where the A has issued the check. Earlier the position was that the complaint should have been filed at a place within whose jurisdiction the drawer or the drawer bank has issued it, right? Now the situation is different. Now it should be from the jurisdiction of the payee. That means if A is living in Aurangabad and B is living in the Bangalore, right? A is living in Aurangabad, B is living in the Bangalore, and the B, one who is a payee here, has deposited the check for the purpose of a credit at the Bangalore. Now check has been dishonoured. The B can file a complaint against the A within the jurisdiction of a Bangalore court, right? Same way you will learn for an HDC, that is a holder in a due course. Or now the point number 2, if the check is presented for a payment by the payee or a holder in a due course, otherwise through an account means by some other mode, the branch of a drawee bank where the drawer maintain the account is situated. Now this is the example we have taken is for the purpose of a physical submission of a check, right? The point number we explained when the check has been presented for the purpose of a payment, otherwise through an account, right? So the section 142, a conclusion with regard to the amendment of a section 142 is that simply on a dishonour of a check, the complaint can be filed within whose jurisdiction the payee is maintaining the accounts. Here in this example, in this reference, it is within the jurisdiction of Bangalore. No doubt the third amendment is also there, section 142. Capital A is inserted, it is a new section inserted, right? Remember, the section is all about transfer of all the cases which were made before the implementation of the amendment, and therefore in my opinion there is no good weightage. There should not be a good consideration to learn or to understand the section 142 capital A when you are appearing for an exam, right? So these 2 points you should keep in mind. Section 6 is with regard to the check and section 142 with regard to the cognizance of an offence. Thank you.